Hi, my name is Carl Pearson, and this video is number 129, which is annul or avoid student loans, no bankruptcy. And my name is Carl Pearson. I'm a New York attorney spending most of my time helping debtors get rid of their unwanted debt. I'm also a graduate of Harvard Law School, and for 18 years was the founder, owner, and president of a for-profit technical school in New York, with most of the students paying their tuition using student loans. So I know the student loan business on both sides. Years ago, I remember that I was the first student to apply for a student loan at the local savings bank under a New York statute guaranteeing student loans for New York students. This occurred before the federal government came in. Tuition at that time was far more affordable than it is now. My tuition at my alma mater was only $21 per credit hour, and I was able to pay off the student loan over a period of years. Today, things have changed. The price of tuition has skyrocketed in many colleges and universities, and I see that my college now charges $1,010 per hour, exactly 50 times what I paid years ago, with total annual costs per student of $48,604, or about $200,000 for a 4-year period. It is not possible for about 50% or more, and I'm guessing at that figure, of college graduates with student loans to make their required payments and maintain a minimum standard of living. This fact creates a possible opportunity for the students and their parent guarantors to be able to get rid of all or part of their student loans without going into bankruptcy court to try to qualify for invalidating student loans because of financial adversity. To have the bankruptcy court invalidate student loans due to financial adversity is very, very difficult to achieve. The conditions are too difficult for maybe 99% of students and their guaranteeing parents to meet. These restrictions are found in 11 U.S.C.A. section 523A.8, which provides, unless accepting such debt from discharge under this paragraph would impose an undue hardship on the debtor and the debtor's dependents. Now, there are different rules in different bankruptcy courts, but generally speaking, it is very difficult to meet the typical conditions imposed by the bankruptcy court to obtain a discharge. Some courts use the Bruner test, in which you have to meet the 3 conditions of poverty, which is based on your current income and expenses. You cannot maintain a minimum standard of living for yourself and your dependents if you are forced to repay your loans. Persistence, that is, your financial situation currently is likely to continue for a significant part of the period of repayment of the loan. And good faith. You have made a good faith effort to repay your student loans and you haven't been able to do so. Other bankruptcy courts use the, quote, totality of the circumstances test, unquote. Those courts will look at all the factors to determine if there is an undue hardship for you to repay your student loans. Obviously, this is a more liberal standard from the student or guaranteeing parent standpoint. But there are not many pro-student decisions to offer much hope to most student loan obligors or their guaranteeing parents. There is a much better way to discharge student loans, but the procedure is not applicable to all students or their guaranteeing parents. It is open only to those students and parents who were defrauded by the college or university when they signed up for their course of instruction. If the school was aware that the student loans were for purchasing a course of instruction for which the typical program graduate did not earn enough income to both service the student loans and maintain a minimum or perhaps slightly higher standard of living, the school should have notified the student and his or her parents before they signed the agreement, but probably did not do so. I haven't heard of any school doing that. This is a standard case of common law fraud which would enable the student and his guaranteeing parents the opportunity of suing the school, the bank, and the guarantee agency for fraud to invalidate the student loans whether governmental or private student loans. Remember that this action of this type should only be brought if it is meritorious. But if a meritorious action is brought, you would expect that the school, bank, and guaranteeing agency would probably be willing to cancel or significantly reduce the loan for various reasons, including 1, the student and his or her guaranteeing parents have no ability to pay, which means that the student loans are virtually worthless anyway. Defending the action would cost money that could go down the drain. 3, a trial could result in liability for damages and punitive damages of up to 9 times the amount of the damages, which could be avoided by cancellation of the notes or reducing the amount owed to settle the lawsuit. And 4, a trial could result in adverse publicity for the school, bank, and guarantee agency. And finally, an adverse decision at trial could be binding on the school, bank, and guarantee agency as to other students under the doctrine of collateral estoppel, or res judicata. I have personally brought such a lawsuit and achieved success, and understand what needs to be done as well as the limitations that exist. In other words, I understand where this type of lawsuit has a probability of success, and also understand when this suit should not be brought for lack of merit or other reasons. The higher the dollar amount of student loans involved, the more realistic and meritorious action becomes. Student loans of less than $10,000 or $15,000 probably are not worthwhile for an attorney to handle, but with outstanding student loans of $25,000 to $250,000 or more, you would want to have an attorney handling the case. I may possibly be of help to you no matter where you now reside. If you want to discuss your matter and explore whether your case has merits, or want to discuss where such action should be brought, or want to discuss costs, please give me a call at 212-307-4444. That's 212-307-4444. I look forward to hearing from you.